Welcome to the first module on criminal procedure. My name is Leilani Delgado Mosalina, your presenter for this course. This course is CLJ 6, described as criminal procedure and court testimony. Module 1, Preliminaries, is a two-part series discussing the following key points. In part 1 of this video series, we'll uncover how criminal procedure is integral to police work, the requisites for studying the subject, the basic principles that underpin it, and then in part 2, we'll continue with an overview of the criminal litigation process and some miscellaneous doctrines that are essential for a criminologist. Now, for the sole purpose of grasping the knowledge and understanding the subject, some slides will conclude with commentaries in Filipino, but it is expected that the students shall be able to express their learning in English. Let's begin by understanding how criminal procedure is applicable to police work. In every aspect of policing, from arrest to evidence collection, it is governed by procedural rules to ensure fairness and justice. These procedures are not just guidelines. They are legal requirements that, when not followed, can lead to the exclusion of evidence, which weakens the case of the prosecution or even dismissal of cases. Next, we will discuss the requisites of the study. Studying criminal procedure requires a grasp of various concepts that you have acquired over the years. In CLJ 1, it involves learning about the pillars of our criminal justice system, the role of various organizations and functions of the law enforcement agencies in the country, the role of the prosecutor, and the hierarchy of courts. In CLJ 2, understanding the Constitution, case law, and statutory provisions that govern the actions of criminal justice professionals. CLJ 3, knowing the nature of felonies such as dolo and culpa, the different types of criminal liability according to participation, the circumstances surrounding it. In CLJ 4, knowing how to identify and differentiate the crimes as described in the Revised Penal Code and other special laws. So in studying criminal procedure, you should have undergone these subjects to fully appreciate the subject. There are several basic principles in criminal procedure that ensure that the protection of individual rights while balancing the need for public safety. Another approach is to know that the study of criminal procedure requires a constant awareness of the mandatory application of certain fundamental concepts. Okay, and then what are these concepts? First is that in every step of the litigation process, all parties are entitled to both substantive and procedural due process. Second is that in all criminal prosecutions involved, the state has the obligation to prove the elements of the crime charge beyond reasonable doubt. And third, compliance with the rules is not an end in itself, but acts only as a means of dispensing justice. So class, you should be aware that in criminal procedure, these three basic principles are always in motion. What is substantive due process? It is the part of the law that creates, defines, and regulates rights which give rights to a cause of action. Simply stated, class, every person has the right to life, liberty, and property. And where can you find these rights? These rights are clearly stated in the Constitution, the law of the land, in particular, Article 3, Bill of Rights. So while the state has the right to prosecute an accused for his or her crimes, there must be a recognition of the right of the accused, that he has the right to life, liberty, and property. On the other hand, the state also has rights in the form of powers given by its citizenry. The police power of the state, for one, which is the power to regulate liberty and property for the benefit of the society. It is the state's right to take coercive action against individuals for the benefit of the society. So in this case, we have penal laws enacted. Let me go back to the power of the state, which is police power. Police power is the plenary power vested in the legislature to make, ordain, and establish wholesome and reasonable laws, statutes, and ordinances, not repugnant to the Constitution for the good and welfare of the people. I need to emphasize the meaning of police power because there was a policeman that was interviewed in the news Class, baka kayo din nalilito sa police power kasi ganito yung sabi ng taong yun. Sabi niya sa interview, after arresting a person illegally with abuse, so that a person was arrested illegally and with abuse, and then they interviewed the policeman. According to the policeman, police power is the power of the police to arrest people and ensure public welfare. Mali yun. First, police power is an inherent power of the state, ng gobyerno, to make reasonable laws. Now, inherent means kasama na yan sa isang gobyerno. Basta may gobyerno, may inherent police power. May kasamang kapangyarihan. Sinong nagbigay ng kapangyarihan? The people at large, by establishing a government, and then the people forming the government are elected by democratic means. So it does not belong, police power does not belong to anyone or a person. A person cannot make laws by himself o kaya mag-decide kung ano ang batas dahil basta pulis siya. Second, it is vested in the legislature, meaning ang konseho ang kumikilos to make wholesome and reasonable laws. The police power refers to the making of laws vested in the Congress of the Philippines, which is further delegated to the local legislature. So walang executive department na pinag-uusapan dito o yung mga tao ng pulisya. I hope that is clear. Now let's go back to the first principle, this time focusing on procedural due process. Procedural due process involves hearing before condemning, proceeding with a criminal case upon inquiry, and rendering judgment only after trial. It also involves notice and opportunity to be heard before judgment is rendered affecting one's person or property. So while the government has the right to deprive a person of his life, liberty, or property, the requirement of due process is that a person must be given a chance to be heard or given notice in the court of law. So this gives rise to the next requirement or awareness in criminal proceedings, which is the state has the obligation to prove the elements of the crime charged beyond reasonable doubt. So recall what is proof beyond reasonable doubt first. Proof beyond reasonable doubt is that degree of proof which produces conviction in an unprejudiced mind. Meaning walang kaduda-duda, talagang guilty ang accused. This applies to criminal cases where the state must prove beyond reasonable doubt all the elements of the crime charged and the participation of the accused. The third principle is that compliance with the rules of criminal procedure is not the end in itself, but only as a means of dispensing justice. Ano ibig sabihin nito? This means that the ultimate goal of criminal procedure is not just to follow the rules meticulously to the letter, but to ensure that justice is served. In other words, the rules and processes that constitute criminal procedure are merely tools to achieve a fair and just outcome in the legal system. If the rules prove to be unfair to the accused, then justice must prevail. Okay, that is another basic principle you have to remember. Now let's continue with the fourth principle, and we have until 9 items under the basic principles, which is, starting with number 4, criminal action is instituted by the state to prosecute a person for an act or omission punishable by law. This is why a complaint or information is in the name of people of the Philippines, because ultimately, a crime has been committed against social order. The fifth principle is that criminal action is judicially commenced by the filing of a criminal complaint or information. So let us find out their basic definitions. For the purpose of this preliminary module, complaint and information is defined as follows. A complaint is a sworn written statement subscribed by the persons mentioned in the rules. Information, on the other hand, is a written accusation subscribed by the prosecutor. What is the importance of a complaint or information in every criminal proceeding? The answer is that the accused must be duly notified of the accusation against him as part of his right to due process. Dapat sufficient ang written accusation against him, such as the name of the accused, the name of the offended party, designation of the offense charged, cause of the accusation, aggravating and qualifying circumstances, if any, the date of the commission of the offense, and the place where the offense was committed. Otherwise, if these are not sufficiently written in the complaint or information, his defense would be that he was not properly apprised or informed of the accusation against him. Hence, he could not properly defend himself in court. Case dismissed. So that is why a complaint or information must be sufficient in form. The sixth principle is for the validity of the court's judgment, the complaint or information must be filed with the court which exercises jurisdiction over the offense charged. It cannot be just any court that the prosecution or the prosecutor chooses. But what does jurisdiction over the offense charged mean? Also known as jurisdiction over the subject matter, it is the authority to hear a case and render judgment. It means that a court has jurisdiction to hear or try a case as the authority has been given by law. It is determined by the allegations in the complaint or information. So, at this stage, upon receiving the complaint or information, the court will have to look into the contents of the accusation, such as the facts of the case, as well as the penalty provided for by law for such offense. You will later learn that there are different courts in the Philippines and that there are laws that set which court will hear and try such crimes or penalties according to their severity. For instance, for violations of city or municipal ordinances, all the cases falling under summary procedure, which you will learn later on, are within the jurisdiction of the municipal trial courts or MTCs. Another example is when a criminal case is filed for an offense punishable by imprisonment not exceeding 6 years. Hindi lumalampas ng 6 years ang penalty of imprisonment. They are also within the jurisdiction of the municipal trial courts or MTCs. And then another example is for cases punishable by imprisonment exceeding 6 years, they are in general under the jurisdiction of the regional trial courts or RTCs. You will also learn later that there are other types of jurisdictions acquired by a criminal court. So let us continue with the principles. The seventh principle in criminal procedure is criminal action must be filed in the place where the offense was committed or where any of its essential ingredients occurred. This is also called jurisdiction over the territory. Why? Because criminal actions are territorial in nature. It is filed in a place where the offense or any of its essential ingredients were committed. If they were not committed in that place where the court sits, it would result to an invalid judgment or that the court acted without jurisdiction. So make sure that in determining which court, well, this is the job of the prosecution, of the prosecutor. But this is important because as the investigator or the police person who is in the field, who is investigating the criminal case, you should be able to identify where the crime has been committed, record it, and be able to sufficiently describe it in the complaint or information, alleging the place of the commission of the crime, because it is essential for the determination of the jurisdiction of the court. 8. The court must have acquired jurisdiction over the person of the accused. A court acquires jurisdiction over the accused by arresting him or he has voluntarily submitted himself to the jurisdiction of the court. You will learn later that an arrest or any arrest must be valid, meaning it must be lawfully made. Class, maraming suspects ang nakakawala sa hustisya because of this. We should know how to conduct a valid arrest. If you unlawfully arrest a person, they will question that later in court. If indeed the accused's rights were violated during the arrest, the court's acquisition of jurisdiction over his person is questionable. And as a result, any evidence gathered, such as confession or physical evidence, may be excluded from trial. This is sometimes referred to as the fruit of the poisonous tree, or the fruit of the poisonous tree doctrine. Therefore, it may result to a situation where the case of the prosecution is weakened because the person has been, or the accused has been, illegally arrested. And you know that when any confession or evidence acquired is excluded, who will suffer? The prosecution. The case of the state representing the people of the Philippines is weakened because you have known that one of the basic principles of evidence is that for a crime to have judgment of conviction, what kind of weight in evidence is required? It is proof beyond reasonable doubt. Always remember that. So the ninth principle is that every person criminally liable for a felony is also civilly liable. Whenever a criminal action is initiated, the action for civil recovery is also deemed initiated. If you recall, in obligations and contracts, obligations also arise from delicts and quasi-delicts. So when a criminal case is instituted, the civil action is also deemed instituted. But is this absolute? No. There are situations where the offended party waives the civil action, or reserves the right to file the civil action separately, or has instituted the civil action prior or ahead of the criminal action. So this is where we conclude the topic on the basic principles in criminal procedure. In the next video, we will discuss the overview of the criminal litigation process. But first, to help you apply the basic principles, I will ask you to do an exercise. Check the link in the description for this exercise. See you in the next video.